And you can start whenever you are ready.
Thank you, Your Honors. In this case, it has a little bit of factual issues that we need to address and a little bit of procedural. I'm going to try and roll through both of those with a quick overview of what brings us here from my client's perspective.
Mm-hmm.
Mr. Amir was, this is a DUI stop. Mr. Amir was stopped the early morning hours in 2021. When he was stopped, the officer promptly initiated a DUI investigation. At that time, part of that process is to blow into a PBT roadside. Mr. Amir said multiple times that he had COVID, he has difficulty breathing. The officer said at some point that he was going to say he refused it after 3 attempts. And I think it's from an evidentiary perspective, it's important to note the officer allowed him to take 8 separate PBT tests. And I think that from a review of the evidence kind of helps us understand, maybe even the officer understood he was having breathing difficulties. He was arrested, taken to the station.
Okay, let's back up just a minute, Mr. Mayfield, because the 3 of us know these facts very well. Mm-hmm. So let's get down to kind of the heart of your argument. You have your primary argument here, as I understand it, is that you believe the judge should have issued summary judgment on your behalf and not included not looked at any of the video, right? You had an objection with that video being reviewed by the judge when he was making a ruling on the summary judgment motion. Is that correct?
Well, it is correct, but it's only such a small part of what's really going on here. Okay. If you want to, I can fast forward it. My client had a medical defense,
right?
And my client utilized the appropriate standards under Kansas law by using the summary judgment process, because getting a physician there is near impossible. Even the judge said that.
Right.
So I put an affidavit in, and it is exactly the same facts and circumstances that were offered to the hearing officer, and it was admitted into the administrative record.
And wasn't the videotape also admitted into the administrative record?
No, I don't believe it was, Judge.
Well, I have here a copy of a letter from the prior attorney saying, here's the video, administrative judge, please look at this. We want you to examine this before you make a ruling in this case. Okay.
Well, I was not the attorney in the administrative matter.
I understand that, but isn't it pretty significant that it was Mr. Amir's attorney who asked that the video be considered by the ALJ. And once that happened, that became part of the record.
Okay.
So I don't quite understand why it would be a problem for the judge to consider that, since it was part of the record.
Well, first off, I would tell you, Your Honor, even if the judge reviewed it, I don't know that I agree with that. Just the mere fact that it's out there. It was not rebutted. There was no, I don't think that judge who reviewed the video can, as a layperson acting in that role, I don't want to suggest that he's testifying or providing evidence. Judges can weigh evidence that's out there, but this is medical in nature. And in this particular
instance, your point is he had a medical condition. And do you agree that at the summary judgment phase, the primary thing we're looking at is whether there's any dispute as to material facts, right?
Yes, that's correct.
And as much as you want us to consider only the medical evidence that was presented and nothing else, there was a dispute on those facts. There was a dispute on whether or not, there was an affidavit from the officer as well as the video indicating that he did blow for 7 seconds on the last PBT test, which would rebut what this doctor said a month later, that there was no way he could blow past 2 seconds. So there was that dispute. And there was also a dispute over how much he told the officer at the scene about his medical condition. So once you have a dispute of facts like that, doesn't summary judgment become impossible?
There are 2 pieces that, as through my practice, 2 pieces of a summary judgment. One is yeah, the judge's ruling on particular issues, I suppose, but also the relevance of the facts that are out there. I didn't call the doctor to my trial in chief, in great part because all the medical issues that I did provide were uncontroverted, and I believe were a part of the summary judgment record, which at some point, not sure when, but at some point merged with the factual record.
There's some evidence that's uncontroverted. It doesn't mean that all evidence is uncontroverted, and all it takes is some evidence to be controverted to bypass summary judgment and go to a full hearing.
Judge, I understand that, and I'm not so certain. This is not an appeal based on the summary judgment as if it's the end all to beat all. It is about what the summary judgment record and the impact it has on the trial and the merits. So even if it's denied, there's discussion about the facts that are uncontroverted are treated as established in the action in chief. So at some point, it may have been controverted by the judge's review that he didn't find the doctor's testimony to be credible, but there was no confirmation as a part of the factual record that it even existed. The part of the summary judgment motion, the facts that went uncontroverted, just didn't, as if they didn't happen. And I'm not suggesting.
I'm still having a hard time figuring that out and how they didn't happen. I mean, he presented an affidavit that he said things to the officer that when the video was reviewed, he didn't say to the officer. And he says he can't blow because of COVID, yet he blew. So those are, to me, the judge doesn't have to reach a credibility determination one way or the other at that point until you get to a full hearing. And then Judge Halbert was perfectly capable of listening to all the testimony and considering all the testimony and deciding, did this man refuse to take the breath test because of a medical condition? And, he said that he did not feel the evidence supported that it was a medical condition that prevented him from blowing.
So if a litigant who's following the rules and files a well-pleaded motion for summary judgment, and in the response to that well-pleaded summary judgment, there is not a response that offers any evidence that controverts those facts, how then do we, when we get to the trial?
So how is it there was no evidence that, they submitted a reply and they answered and they said, they pointed to these factual discrepancies and they even time stamped it to the video as to when he said certain things in the video and when he was able to blow for 7 seconds to the point the officer had to stop him. Your Honor, I'm talking about my motion. And maybe we're melding together trial and I'm talking about the specific facts that were contained. I'm talking about the motion, and then the response to the motion set out this dispute. And that dispute remained throughout the hearing, and the judge resolved that dispute.
Yeah, but there's not a reference to any of the medical testimony. And I said medical.
He does mention the medical testimony in his order, doesn't he? He says, I think that the evidence controverts the medical testimony because the medical testimony is, it is impossible for him to blow more than 2 seconds. And we know that he, a month earlier, at least a month before the physician's assistant came up with this statement, we know he could blow for 7 seconds. So the fact that she says there's no way he can blow past 2 seconds is absolutely controverted in the record.
So did the judge's review also would indicate that he didn't have asthma? He didn't have any breathing problems? He didn't have bronchodilators that he was required to have for a couple of years? Or, is that make all that not credible? So it's not admissible. So it was just ignored. That's my
counsel. Even if you assume all of that to be true, and I have no reason to doubt that, it looks like Judge Haber was relying on the fact that based on the evidence, either that was presented in response to your summary judgment motion or ultimately at the bench trial, the key issue for him seemed to be not whether he had a medical condition. He certainly may have, and it sounds like he had COVID at the time. But the question appears to be, was there any evidence that he could offer a breath sample longer than 2.5 seconds? Seems like that was the issue that he was concerned with. And in his motion to alter or order on your motion to alter or amend the journal entry, he says that had you offered testimony from an expert that it was more difficult to provide a breath sample into an intoxilizer than a preliminary breath test, that the court would have considered such testimony. So what's your response to that?
Well, I'm not, frankly, I was just sitting here thinking, I'm wondering if to make this statute really defensible, we'd have to have a treating physician and an expert rendering an opinion in the booking room at the time we're watching it.
Or in your case, if you came forward pursuant to KSA 60-226 and presented a letter or an affidavit from a physician saying that he is incapable of breathing over 2.5 seconds, certainly that introduces it. It isn't conclusive, but it certainly would be admissible in court. Then the state would have to respond to that. And here, the way at least Judge Haber says that he had the ability to exhale for 7 seconds.
Yeah, I guess my concern, Judge, is I don't know what 2.5 seconds is. I don't know what 7 seconds, how that relates necessarily to whether my client had a medical condition that each time he took successive, it was more painful, it was more difficult.
Because the cause of the medical condition, you need to establish causation, that the medical condition caused his inability to offer a sample and not simply refusing. And I want to go back real quickly just for both counsel. The letter that the chief was referring to was October 1st, 2021 from Charles Green, who was the previous counsel for the appellant, to the administrative hearing officer, offering the DVD containing body camera footage from Officer Eddings, and then says, quote, "I appreciate you viewing this video as it pertains to Mr. Amir's informing Officer Eddings of his medical condition and ultimately his inability to take the intoxilizer," period, close quote. So it seems pretty clear that it was offered for the purposes of his medical condition and his claim of inability to take the intoxilizer. So it looks like it was in the record, at least below.
Well, and to speak to that, Judge, at some point, the fact that you're putting a video in there to say it wasn't a big surprise, it wasn't something we woke up about a week after the arrest and said, I think I had the sniffles and I want to allege a medical defense. The fact that a video was there still gets us back to whether a judge looking at it can render by counting off seconds. Now, I understand it may be off from her allegations of 2.5 seconds or whatever that was, but it doesn't, all the other pieces of that about his inability, about how he declined after multiple tests, it's medical in nature. And I just think you can run a stopwatch and say, well, now, since there's some inconsistency between my stopwatch and the doctor's stopwatch, somehow that supersedes whatever the medical testimony is. I just don't.
We're not understanding each other at all then, because let's say the medical testimony, the affidavit said that he has this medical condition, and it makes him would have made it very difficult, if not impossible, for him to blow in the intoxilizer, and had not put a 2.5 second or any kind of second limitation on it. He has a condition that it would have made it impossible. But by putting in that 2.5 seconds, it threw into question everything in that affidavit, because she said it's impossible, but we know he did it.
Okay. Well, I wasn't there when it was drafted, and the word impossible is always difficult in any kind of medical circumstance. But I don't think the words asthma, and I don't think long history of breathing difficulties right,
but the question is, did that prevent him from completing the test?
Well, he said it did. And the statute says if a person didn't perform the test, then they got to come forward. There'll be a refusal unless they come forward with medical evidence to provide the basis for that, unrelated to the consumption of alcohol. And I frankly think and very strongly feel there's two things going on, and there is that evidence. It was not considered. It was, and I say not considered. Maybe it was not given the credibility and weight that individual numbered in a motion for summary judgment, numbered contentions of uncontroverted facts, which go uncontroverted in that motion. With no medical testimony. And I guess I'm drawing a line between medical testimony. Even the judge said, "Oh, these are all going to be uncontroverted unless you depose the doctor or get your own expert or get somebody else." So we don't have any medical contravention that goes on here. It's just common sense, and it's disregarded. And to Judge Arberger's comments that, okay, so there's an issue now, and it's appropriate to go have a trial on the matter. Well, those facts still travel into the trial, I think, but they're not articulated in the order, and they're not articulated in the final findings by the court. They're just never minded. They're just
doesn't the video go into the trial also of the stop?
Yes, of course.
And so then it's a question of the court determining whether there's a controverted fact for summary judgment.
Your Honor, after the fact, and this is where procedure runs a little bit afoul from my perspective. I don't know if the summary judgment facts, the summary judgment record, merges with the trial facts. They were both open, not fully resolved until the final journal entry by procedure. But I assume that the facts that flow from a summary judgment motion that remain uncontroverted continue on through the merits of the trial itself. And I'm not talking about the 2.5 seconds or the impossibility. I'm talking about the other my client's testimony that he was having difficulty. It was getting worse. It was painful. He was and had articulated it by no surprise prior to the officer asking for a breath test. And he also offered, and being polite and cooperative, he offered to take a blood test at the scene and at the station. And officers get to choose their tests. But at some point, I think officers have some obligation to accommodate. Public policy indicates that having a test result is more favorable than getting somebody to, having a refusal in their file. So,
okay, are there any? You're into your rebuttal time now. Are there any other questions from the panel?
No, I'm saying for.
Okay. And you'll have a good chance at rebuttal.
Thank you.
Ms. Nguyen?
May it please the court. Coming from what the opposing counsel just said, I think most of this is explained in the district court judge's order on the petitioner's motion to alter or amend the court's journal entry of judgment. But from what I gather from his recent argument, he's saying that the medical testimony or the medical evidence that was put into the affidavit that was quote unquote uncontroverted, which was some of the facts, not all of them, should have somehow been addressed in an order or a journal entry. In that order I just quoted from, the judge actually says, a lot of this was at trial. A lot of this information is now moot, or if it is uncontroverted, it didn't have really any weight given to it because of the nature of the specific fact. And so, the fact that the physician assistant saw the petitioner or the appellant and gave him medical advice, the judge didn't have to address that because he didn't feel as though it was necessary to address each individual fact of the affidavits. And he doesn't need to. In his brief, the appellant even states that, or tries to argue that, the court has to follow or abide by the statute for summary judgment that the lawyers have to. And the court also addresses that in his order, stating that, no, that's just for the litigants. That's not for the court itself. The court doesn't need to address an affidavit one by one, each paragraph, and state whether it's controverted or uncontroverted. They just need to make an order on the facts given and given the testimony and the evidence and the record itself. And so I'm not sure exactly what he's trying to argue, but I would like to address the statute KSA 8-1001 subsection P.
And do you believe that requires an attempt first?
Yes, that's our position as the Department of Revenue, and I'm sure that you guys have read my brief. I would say that in my brief I do quote Drake versus KDOR, which also I think is a good case for our argument that given the language of the statute, and if we did a plain reading, there's a reason why the statute starts with the word failure and not refuse. We think that in order to fail something, you would need to at least try to give an adequate breath sample. If we were to adopt the position of the district court judge in that issue, then it wouldn't make sense for public safety. If we, and also another statute in that same section, but I'll get into that after this. It just doesn't make sense to allow a person that gets pulled over for a DUI, suspected of a DUI, gets arrested for a DUI, to then tell an officer, hey, I don't want to take a breath test because I don't know if I want to, but I'll take a blood test. The statute, another statute, states that an officer gets to pick the test, not the licensee. If we allowed the licensee to state that, oh, for medical purposes or a physical inability, I'm not going to do such and such test, it would not make sense, given that there's another statute that says the police officer can pick it. If we allowed the licensee to not even try to take a breath test and show that they can't actually do it, then I just don't think the statute would have much weight to it.
Mm-hmm.
We also, I believe, cite a few like Creasy and Chastain in that argument as well. Also, I would also like to make a point to say that the summary judgment hearing occurred, an order was drafted, and on the day of trial, the other attorney or opposing counsel filed a motion to amend or alter that order of summary judgment. And there was no continuance of the trial. The trial was heard on the merits of the evidence, and a decision was made. It doesn't make sense to try to appeal an order for a summary judgment after a trial has been had and an order or a decision has been made on the trial, given that a summary judgment is just it has an interlocutory character to it, and it's just simply like a step along the route to a final judgment. Here, a final judgment occurred once the case proceeded to trial, so a full record was developed in court, and we're taking the stance that that record in court at trial supersedes the record existing at the time of the summary judgment motion. Does the court have any other questions for me? I don't have.
So I just to get your statutory interpretation argument clear, the statute says failure of a person to provide as directed. Whoops, I gotta get my glasses on. constitutes the refusal unless the person shows that their failure. You're saying because of that word failure in there, you have to have tried and failed, not just refused.
Yes, and we also base that off of the definition of refusal that is found in the statute as well. And I explain it in my
Right.
brief.
I'm looking
quite
at
a
you.
bit. Okay. And
Okay.
oh yeah, and that's fine.
Okay.
But our position is that because the legislator or legislators did not put refusal of if a person refuses to take it due to a medical condition, then it would mean something else. But they use the word failure twice in there. There's never, if they use the word failure twice and it constitutes a refusal, then our position is that failing means that you had at least attempted to do that test.
So wasn't the ultimate question presented at the trial de novo whether or not he had the capacity to give a sample, and you're saying he didn't even try, but even if he had tried, there's evidence that he could, in the record, that he could blow for 7 or 8 seconds. Is that accurate?
Yeah, and he did take 2 different types of tests. He took the preliminary breath test, and he had 8 tries on that, and I believe one of the blows lasted 7 seconds, which controverted some of the facts in the affidavit. For the intoxilizer, the chemical breath test that the statute, KSA 8-1001, I believe, it latches on when it's the intoxilizer test. And
right, but was there any evidence that there's a distinction on my ability to blow into a preliminary breath test machine versus blowing into an intoxilizer machine?
There was no evidence to presented that any.
Seems like the medical capacity to blow into a machine would be the same unless there was some evidence to show that there's a difference in the mechanism.
Harder,
yeah, I agree. And I'm just saying that the appellant did not bring forth any evidence that it would be different.
So it's your position that once the summary judgment been granted, of course, it would have been a final judgment and it could have been appealed by you. But once a summary judgment is denied, it's interlocutory in nature, and basically you go to trial, a trial de novo, and that's what happened in this case.
Yeah, yes and no, Your Honor. I would state that if an order for summary judgment is a denial of summary judgment, then it should be appealed before it even goes to trial. Because
we usually don't take interlocutory orders from denials of summary judgment motion. So you could try, but probably we wouldn't grant it.
I meant appealed as in the motion to alter or amend should have been filed and decided before it had gone
to get the district court to look at it if they believe there was any mistakes. And they did that, right? But now you said they did that the day of trial. But he issued an order on that, fairly comprehensive order, denying the motion to alter or amend, didn't he? The district court judge. Okay.
Yes, he did. I have no further information or arguments to.
Okay, thank you.
Thank you.
Mr. Mayfield, you have 3 minutes.
Thank you, Your Honor. Maybe from my days serving in the legislature where I cared what the statute said, counsel did direct that the plain reading of the definition, the one place where they do define what things are, not just, we don't have to guess, but they define a test refusal or refuses a test is found at 8-1013. And I is the relevant one, but it's interesting because it uses the word or. And it's been a little bit of my complaint about the litany of tests that have interpreted medical did they have any evidence? Did he try? Did he not try? And I thought of scenarios like a person had their mouth was wired shut. That's not what we had here, but no, you got to do the fiction. You got to try. And in this instance, Mr. Amir said repeated, declined. It was painful. It was hard. He was operating in good faith. But in the statute, it says that a refusal is a person's failure to submit. Now, I'm not saying it's a refusal, failure to submit, but then there's the word or complete a test. So it's okay if you got up to the machine and faked it. So that would fit into he submitted, but then he didn't complete it. I mean, there has to be two separate ways to look at that if the word or is in the middle of that definition. And I submit to you that he failed to submit, and he had a medical reason to back it up. And it was uncontroverted. In his testimony at trial, whether we don't like the doctor's testimony, his testimony was that it was painful. It was hard. It was more difficult as we went. And it didn't say to tell the officer. It says to have a medical defense. And that medical defense was provided to the district court judge in this case. It was uncontroverted. The pieces of the pieces that I think are uncontroverted, I'm fair that the 2 point, but it said things like repeated attempts would cause fatigue. Every attempt would be less in length and volume. And
that didn't happen here. Subsequent were longer.
I don't actually think we know that, Judge. I think we may have pressed him to a point where it created further disability. We don't know.
But these questions could have been presented, and I know you weren't the trial counsel or I don't know if we call it trial, but the bench, we'll call it a bench trial, the administrative trial, or the trial de novo, I'll call it. And I know you weren't the counsel there, but had the doctor come in and testified, maybe they could have gotten into some of those other issues. Instead, counsel would have known once they got the order on summary judgment motion that Judge Haber was quite concerned with this 2.5 versus 7 seconds that he viewed in the video that was in the record and put in the record by counsel for Mr. Amir.
I can't speak to what Judge Haber, what he was thinking at any juncture.
Well, he put it in his order. He put in his order that I was just looking at it. I'd have to go back through, but he put in his order that he had pointed out that he had concerns about the fact that the physician had rendered an opinion that he could only breathe into it for 2.5 seconds when he saw a video where he could exhale for 7 seconds. So, I mean, it's not like anybody was surprised about this, and that this is the evidence that once the summary judgment motion was denied, that if there was all these you've made some good arguments, but if these good arguments had been presented to the trial court, perhaps it would have been a different outcome, but that's not our job. Our job is to review the record on appeal and make a decision based on that.
Yes, sir.
Okay. Anything further?
No.
Okay.
Thank you.
We'll
Thank you both.
take
Good
this
arguments.
matter under advisement and issue a decision.